Well, hello and good afternoon to everybody. We're going to make a start now, so I hope you're all sitting very comfortably. So a warm welcome then, and thank you ever so much for joining us today. As always, I'm going to start by making a little introduction. So my name's Karen Faulkner, if you've not joined us before. I'm the HR Knowledge Manager at HR Solutions, and I'm going to be the lead presenter today. And I am also joined by my lovely colleague, Ateem Arden, and she's here in the background to field any technical problems that you might have. Now, hopefully there aren't going to be any, of course, but just in case, she's on hand. So if you did just want to drop her a message using the control panel that you have, please do. As always, we will be recording this session, so if you did want to listen back, then you will be able to on our website. And equally, if you would like to have a copy of the slides, then please do send me an email or drop us a message, and we'll arrange for that to be sent to you directly. So the structure then of the webinar today, we're going to look at covering who needs to complete an impact assessment. We're going to look at the steps of a data protection impact assessment and why that will ensure privacy by design. Okay, we'll look at all of the components of an assessment, and that will lead us quite neatly onto doing a quick recap on the legal basis that are required for processing personal data under the GDPR. And we will also then recap on examples of organisational and technological measures, and we'll round it off with a new look at security, okay, which we've not done yet as part of these compliance sessions. Where I talk about recap, it's things that we have covered in previous webinars, particularly my HR perspective on GDPR, which is available still on our website if you did want to have a listen to that. Okay, so there are some things that I'm going to have to assume a level of knowledge for that we have covered off previously, but I'll try and do quick updates while that might be important to what we're talking about. So hopefully then, by the end of the session, you will know whether or not a data protection impact assessment is applicable to you and whether or not you're obliged to complete one. Hopefully you'll understand as well how the concept and the components of an assessment can be used to achieve this elusive concept of privacy by design. And I hope you will agree as well. I've certainly done my best to, but to try and provide you with a really methodical approach to reviewing your internal processing, in relation to this privacy by design and a data protection impact assessment requirement. And lastly, I just hope you'll feel a little bit more comfortable with it all by the end as well. So here goes. Part one. Who needs to complete a data protection impact assessment then? Well, I'm going to forewarn you, if you thought this was going to be one of the few potentially straightforward answers to a straightforward question, I have got 7 slides on this, so you might just want to shuffle around and get comfortable, okay? But hopefully you will see why it was necessary to do that. So here we go then. In order to try and answer this question, we need to go to 3 places, all right? So we need to look to the Information Commissioner's Office, who are the UK's supervisory authority on data protection, okay? Then, of course, it perhaps goes without saying, we need to look at the actual regulation itself, the General Data Protection Regulation. And further to that, we also have guidance from what's called the Article 29 Working Party. Now, you don't have to be too concerned about this, is it another body that I have to be registered with and so on and so forth? No, it's not. If you've not heard of them already, it's essentially, a very legitimate and legal board that's been set up as a result of, and in direct relation to the writing of the General Data Protection Regulation. And they're a group of people who essentially interpret the regulation and try and put it into layman's terms so that you and I can understand what on earth is actually, you know, expected of us in real terms. Okay, so I've reviewed that guidance and I have portrayed it here in this webinar today for you. Okay, so we'll start with the supervisory authority, and the reason for that is because the GDPR does set out that each supervisory authority, so, you know, the UK's is the ICO, and then Holland will have a Dutch one, and so on and so forth, but each supervisory authority has been told to publish a list of practical examples, really, of situations where we would expect a data protection impact assessment to happen. So what do the Information Commissioner's Office have to say? Well, I'm afraid, and this is as of last night, because I did do a double check to see if there's anything new, but they are saying we are working to update this guidance to reflect the provisions of the GDPR. Okay, so that's one of three dealt with in this session. It's a bit exasperating, but at the same time, you know, if you're feeling like you're not quite ready yet for GDPR, then imagine what it must be like working in their offices. You know, I bet they are frantic. What they have done, though, is they have said that we can use their old guide, you know, which is nice, isn't it? So the ICO do have a guide on impact assessments, but it has, of course, been written under the Data Protection Act 98. So, you know, it is still going to be a good starting point, you know, joking aside about the poor souls. The Data Protection Act is not too dissimilar to the GDPR, but, you know, if you were going to read it, you would ideally have an awareness of how GDPR differs, you know. So it is still going to be a really good starting point. You just have to bear in mind the fact that it is out of date. No two ways around it, really. So moving on then, not got very much to work with there. So let's look at the regulation itself. So if you did want to do a bit of light reading, it's Article 35 that you would need to flip to, and that's the article in the regulation that discusses the DPIAs. So it does tell us that we should be particularly considering completing a data protection impact assessment whenever we start to use new technologies. Okay, so if a new piece of software, for example, was to hit the market and it was the next best thing, you know, and people started using it, we would be expected to have conducted an impact assessment before using that technology, okay, to assess the risks attached to it. You would also be obligated to complete an impact assessment if you process personal data in a way which is likely to result in a high risk to the rights and freedoms of natural persons. Okay, so it's interesting there that it does say natural persons, it doesn't say data subjects, which, you know, is the phrase that's normally used. So we have to read that as though this applies to the data of anybody, you know, really, that might be affected. You will also be required to do one if you conduct a systematic and extensive evaluation based on automated processing, okay, but only if that automated processing should produce legal effects or if it might significantly affect a person, okay. So we did cover briefly in my last webinar what is meant by systematic, you know, and it is just the standard interpretation you and I would think of. So, you know, arranged, methodical, part of a plan, things like that. And that's all it really means, but it's just how, you know, broad the scope is of the types of data categories that are covered by the processing. You know, that has a bearing on the extensiveness as well as the number of subjects and things like that. Okay. You would also need to complete one if you conduct large-scale processing of special category data or data relating to criminal convictions. Okay, and again, large scale is a term that we have looked to cover off, and we have got guidance on that from the working parties. We are looking at, you know, the number of data subjects in terms of a really significant scale, you know, like a proportion of the population, you know, thousands of people really we're talking about. You know, consider the geographical extent of the processing and the duration and how permanently, you know, that data is processed. And special category data then is the new phrase for sensitive data. Okay, we can still use that term, but it's just not written in the regulation. And lastly, you would have to complete an assessment if you conduct a systematic and large-scale monitoring of a publicly accessible area. And that's really just talking about things like CCTV footage, recruitment agents perhaps who are quite large, who are regularly monitoring LinkedIn, for example, that might also fall under that stipulation. So if any of those bullets there apply, then you may consider yourselves in for the task of completing an impact assessment. Okay. It's a shame really that it is still quite, you know, a lot of legal jargon in there, I'm afraid, and I wasn't able to give any more practical examples, but it's what we have got to work with, I'm afraid. So it is going to be a case of us trying to realistically, you know, not bury our head in the sands, but try and confront this head on and think, right, could that apply to me and my organisation, my business? So the only part in there that I've highlighted that I've not really gone into a lot of detail about then is this rights and freedoms, high risk to the rights and freedoms. It sounds serious and it comes up quite a lot. So I've got a whole slide on this bit. So let's have a look at what that means. The rights and freedoms are concerned with the statutory rights that someone would have under the data protection regulation, so the new one. If you did want to see a list of those, you know, they are on the ICO website if you wanted to go and have a look. So it's all of those rights that are set out there, but it also includes other fundamental human rights, okay, such as the freedom of speech, thought, movement, the prohibition of discrimination, the right to liberty, conscience, and religion as well. So if you feel that your organisation collects or handles data in any sort of way that could have an impact on any of those rights or any of these freedoms listed here, then certainly you would need to consider yourselves in a position where you would really need to be carrying out one of these impact assessments. Now, I have scoured this article of the regulation, and I do believe that there is a get out clause in there. I'm not sure how many people it's going to apply to, though, I'm afraid, but I've put it here just in case any of you, you know, might thank me for it. So you won't have to complete an impact assessment if you have a legal obligation. So that's one of the lawful basis upon which you would be collecting and processing data. If you have a legal obligation to process data, or the processing that you do is carried out in the public interest, okay? And I just want to pause there. When I talk about public interest, it's organisations, I know these are big ones, but like the Disclosure and Barring Service, okay, the DVLA, you know, organisations that are principally set up to serve the public, really. So if you have either of those things and an assessment has already been carried out, and that assessment was completed when trying specifically to adopt, you know, compliance with this legal obligation that you have, or this need to serve the public interest, then you won't have to do one again. Okay, so I'm not sure how many people will think, yes, that's me, woo. But if it is you, then rah, and if not, then sorry. Better keep listening. So lastly then, we had the three. The last one of those was the Article 29 Working Party. And this might be, I don't know, where we sweep up the last few people who might think, maybe I don't need to. So bear with me. The Article 29 Working Party have released a document, several pages long, it's quite dense, and I just want to read a section to you that particularly relates to this. Okay, so bear with me because it is quite dense, but and the reason also why I'm reading this out, by the way, is because I didn't want you to think it was me just saying it, and you know, I don't want to be accused of scaremongering or anything like that, because I know that is happening a bit with GDPR and advice, but I directly quote, "The mere fact that the conditions triggering the obligation," okay, so those are the things we've just looked at, you know, when a DPIA would be required. So the mere fact that conditions triggering the obligation to carry out data protection impact assessments have not been met does not, however, diminish controllers' general obligation to implement measures to appropriately manage risks for the rights and freedoms of data subjects. In practice, this means that controllers must continuously assess the risks created by their processing activities in order to identify when a type of processing is, to quote, likely to result in a high risk to the rights and freedoms of natural persons. So if you thought that merely those bullet points didn't apply to you, that you got away with it, then perhaps you should think again. And if you're in any doubt about whether that means that everyone should perhaps be doing something akin to a DPIA, then they go on to say in the footnotes, no less, it has to be stressed that in order to manage the risks to the rights and freedoms of natural persons, the risks have to be identified, analysed, estimated, evaluated, treated, and reviewed regularly. Controllers cannot escape their responsibility by covering risks under insurance policies. So straight from the horse's mouth, cannot escape. All right, so what does this mean? Clearly, the Working Party 29 expect all controllers to do those things: identify, analyse, estimate, evaluate, mitigate, and review risks. Fine. I would put to you that you can't know categorically, you know, or without doubt, whether or not your processing puts these rights at high risk, unless you have followed something akin to that advice, you know, unless you have identified your process, analysed the steps of it, you know, estimated what kind of risks potentially could happen as a result and how significant those risks would be, you know, then how would you know whether or not you've got high risks in your processing? You know, you've got to do a level of scrutinising to get to that point. You know, so if you did all that and then the answer came out, you know, no, my processing does not result in high risk, you know, then great, brilliant, you know, you've taken quite a few steps there, but you've come out with no. So then you're just left having to go through your processes and try and ensure that this concept of privacy by design is ingratiated. But if you did do those things and you ended up with the answer, yes, my processing does result in a high risk, then you have to complete an impact assessment, won't you? Okay. And now I have paraphrased this to try and illustrate a point, okay, but I assure you it's very succinct with what is required under a DPIA, but you would have to then identify and analyse your processing systematically, estimate and evaluate how necessary and proportionate the processing is and the risks that are involved. And then you would have to implement measures to mitigate the risks and conduct regular reviews. So if you just compare that then with the bullet at the top of the page, you might see where I'm going with this. It always seems to me, you know, and I am happy to have other views put across and we can try and battle this out together because we are finding our path here. But it rather seems to me that we almost have to conduct at least a mini data protection impact assessment, okay, because we need to establish, you know, what the risks are and try and keep on top of them as advised by the WP29. This would then tell us whether or not processing is likely to result in a high risk. And then if it does result in a high risk, we would have to conduct a data protection impact assessment. So you almost have to assess whether or not you need to do an assessment. And you come full circle, don't you? So I think maybe we all need to consider that we just need to do one. Okay. If you disagree, drop me a line, let me know why. I just really strongly think that for us to stay on the straight and narrow, you know, we have been prescribed a set number of things that would be expected to be seen in an impact assessment. And, you know, my next section of this webinar is going to explain to you why I think those steps will ensure this concept of privacy by design. All right, so privacy by design is something that we all have to do, okay, regardless of whether or not you would think you have to do a data protection impact assessment. You would have to do these aspects that are required under privacy by design. And so I want to just show you what these are. And then what I'll do is summarize why the steps of a DPIA will ensure privacy by design. So let's look first then at what it requires. Okay, so again, if you wanted to have a look up yourself, you would flip to number 25, the Article 25, which explains it. So when deciding how processing should happen, and that's important because essentially it means it needs to happen before we do any processing. Okay, so that might make you start thinking about the deadline of the 25th of May coming around. Really, this should have been happening before we do any processing, and certainly should be being reviewed during processing. So we need to get sorted now. You are required, or your controller is required, to implement technical and organisational measures. So we've mentioned this a few times in the webinars, and the reason is because the regulation itself does keep placing emphasis on both technical and organisational measures, okay? And these are necessary to achieve the 6 principles of the GDPR, again, which we have discussed previously, okay? 2 in particular that are relevant here are the minimisation and integrity and confidentiality principles, okay? So you'd need to work through those principles and think about what technical things and what organisational things you can put in place to achieve those principles. After that, you would then need to integrate appropriate safeguards, and it is in the regulation itself, it uses the phrases state of the art. Okay, so where you can afford it within reason, you would have to use the most state of the art tools, equipment, things available to you to be able to implement the safeguards that are necessary. And you would then have to ensure that only personal data that is absolutely necessary for the purpose is processed by default. By default, okay? So you can't just rely on your staff or your colleagues, thinking to themselves, oh, I won't collect that then. You almost have to design processes that will mean they're not prompted to collect anything that they wouldn't need, So it might mean, revisiting forms and things like that we get people to fill in, for example. And this aspect also includes, the period of storage, so we're not storing any data for any longer than is necessary in relation to the purpose. Okay, so you may need to start thinking about your retention periods. I have written a retention and destruction policy, for example, for the clients we have here, and you've really got to take a fresh look, because there are a lot of habits that we get into that are just not going to be compliant, but there are also a number of statutory laws and things like that you would need to make sure you're still observing. And lastly then, on privacy by design, you've got to ensure that personal data is not made accessible to an indefinite amount of people, okay, without the subject's intervention or agreement, okay. So that might sound fairly obvious, but actually it probably really helps us to visualize thinking about our organization as being almost in a bubble, if you will, and you need to make sure that there's no leaks, and that only data that is needed is going to the places within your bubble, or, to any other organizations that you might have deliberately decided to share data with. Okay, so privacy by design, it does centre much more around how the principles of GDPR can be achieved rather than looking at risks. But you might agree that it is prompting very similar tasks, to the DPIA. So putting measures in place to protect integrity, which after all is privacy and security. Putting in safeguards, to mitigate that is clearly the same sort of thing, So if you follow my train of thought there, and can nod and agree that that's an awful lot there that is really akin, if not just a rewrite of when a DPIA is required, then hopefully you'll see why I think we could all stand to learn the components of a data protection impact assessment and just apply that when we are reviewing our internal processes. So let's stop bleating on then, Karen, and have a little think about what the actual components of a DPIA are. So there are a minimum number of aspects that should be in an assessment. Okay, so if you do think it applies to you, you've got to have 6 of these things as a minimum. And if you feel like going an extra mile, you can invent other aspects to go along inside it. Just don't show off too much, okay? So if you were looking at the regulation, Article 35, there's 4 bullet points underneath it, and they're really dense, and they have quite a few different elements to them. And they're not necessarily in a very logical order either. So because I really want this webinar to be about how you can get compliant, what I've done is I've broken those down okay, and reorganize them into what I think is a much more logical sequence for working through your processes to make sure that they're compliant, okay? So there are 7 aspects that I've extracted from this article. The first 6 are the compulsory ones, okay? So let's start then. We've got purpose right at the top, okay? So we need to have a very clear statement of the purpose for which you're collecting and or processing personal data, okay? So let's say it was recruitment, it would be the genuine need to fill a legitimate vacancy in my organisation. That could be it, okay? Tick. Second one, legal basis. Right, so if you are obliged to do a DPIA, you must set out, okay, whether or not you're relying on the legitimate interest, okay? And we are going to look at the legal bases in a moment, just to refresh your memories. But if you're relying on legitimate interest, you must stipulate what that legitimate interest is, okay? It would be no good just to have, you know, step 1, purpose, to recruit, step 2, legitimate interest, okay? You would need to explain why that's a legitimate interest. Now that can be, you know, don't panic too much, it can be, you know, a genuine business activity. You know, this is the nature of our organisation, and this is what we use personal data for. You know, if you, let's say that you are a marketing, you know, consultancy, for example, and people outsource their marketing to you, you're going to have, you know, loads of lists of email addresses and things like that, and they might be quite extensive, but you might be able to say, I have a legitimate interest to have all of these because X, Y, and Z. You would need to be careful with that, particularly because that example sits quite closely to the requirement for consent, okay? But just trying to give you an example that, you know, this is workable. The third component of a DPIA then is proportionality. So that might sound like quite an insubstantial aspect, but it's very important, okay? It is specifically focused on in the regulation, okay, because it says that there is a requirement to assess both the proportionateness and the necessity of the data that you are collecting and plan to process with regards to the purpose, okay? So it very much goes back to the principles of minimization. You know, do I really need this? You know, we tend to have a culture, you know, of application forms, for example, or any type of form really, and we're so used to seeing in our culture them beginning with things like first name, last name, preferred to be known by, you know, address, work address, home number, mobile number, date of birth, cat's name, dog's name, star sign. You know, we don't need to know all that necessarily. We might do, and if you can justify it, then great, but we're going to have to break that habit, which I think is really quite ingrained. It's probably going to prompt you to have a look at an awful lot of forms and things like that that you might have in your business. And, you know, just take each aspect of the form and think, do I need to know that for the purpose of this form? You know, let's take recruitment again. If you're using an agency and not directly liaising with candidates yourself, you know, do you necessarily need to know their name, their address? You know, they might have even put one of those dodgy photos in the top corner. You know, do you need to know all those things if you're just screening the CV? You know, do you actually just need to know, for the purpose of recruitment, whether or not someone's got the skills, the experience, the qualifications for the job? You know, because things like name and address, it can give away a lot more than, you know, we might always initially realise. You know, a name alone could give away gender, it could give away ethnicity, it could give away religion, you know, straight away. So those would then be special categories of data, you know, that you don't need. And special category data is prohibited from processing if it is not legitimately justified. So proportionality is a really key one, and I can't stress that enough, really. Don't know if anyone's seen, there's a great advert on TV at the moment, and I can't think of the life of me what it was about. I think it is a recruitment advert, actually, for an agency, and there's someone, you know, talking about how, you know, what do you think I look like based on my voice, or who do you think I am, you know, and it's just so, I just think that's so poignant to this stuff at the moment. But anyway, I digress. Process. You would need to set out a step-by-step account of a data process, okay, right from how the data is obtained and collected, right through to how you use it, store it, and or remove it, okay, start to finish. So let's think about recruitment again then. So you might have a recruitment agency will email through or upload to an information system CVs and things like that for me to screen applicants by. Okay, who then has access to that system or that email, and how is that email account protected? How is that system protected? When someone reviews it, are they printing it out, you know, or are they just looking at it in their computer? Is anybody walking past their computer who shouldn't be able to see that kind of data? And then what happens? How do you communicate back to the agency who you want further information about, you know, and how do you collect that information from them, and how do you then store it thereafter? And if that person's not successful, what do you do? What happens to it? And so on and so forth. So it's that level of detail that we need to go in. Risks is next. It might be a fairly logical one after you've set out the step-by-step process, because you can think about the weak areas of that process, okay? And the weaker areas will quite often be where information has to be communicated from one party or one person to another, okay? Because it could be intercepted. So you would need to set out an assessment of the risks that could happen and how they would affect the rights and freedoms of data subjects. And then equally as logical, you need to set out what measures you will put in place. Again, I'm using the words technical and organisational just to hammer it home. Measures to minimise those risks as far as possible, okay? So that you've provided adequate and appropriate level of security to protect the personal data. And please, 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 you know, I did mention retention and getting rid of what you don't need, but this is certainly an area where you would need to be keeping evidence. All right, it's not about personnel and what they're getting up to or not getting up to, but it's just going to be such a shame if you do all this hard work, put all of these measures in place and don't have anything to demonstrate what you did, because I've mentioned in previous webinars, you know, that enforcement is a lot stronger with GDPR than it has been under data protection, and this is why people are taking it that much more seriously, and you know, which was the whole point. And supervisory authorities, so the ICO, if you're UK based, could, you know, contact you. They could want to come and visit, you know, and don't get me wrong, they have stressed very much that it is, you know, a supportive role that they want to play rather than, you know, setting out to penalise people. But, you know, ignorance is never a defence, and it won't be in this case, and they will want you to be able to demonstrate what you've done, okay? And a quick way of demonstrating is having a paper trail. Yeah, so please, please, please do keep some evidence of what it is that you've done to achieve this. You know, indeed, we've even had guidance from the Privacy Professional Institute that, you know, there's going to be a layered approach to how supervisory authorities will review compliance, and part of that layered approach is the documentation that an organisation has to, you know, demonstrate their data policies and the measures that they've put in place. Lastly then, we have views. So this is the optional one, but where appropriate, the regulation does encourage that the views of a data subject is sought regarding processing. All right, so I suppose it's trying to encourage the concept of transparency again, and it's really trying to stop us working in isolation, deciding what's best for business and steaming ahead with it. You know, if we're affecting people, we should be involving those people, not evolving, that's quite a different job. Involving those individuals in how we're dealing with their data. You know, it's their property, it's their information, it's private to them, and it does, you know, stand to reason in a fair society that if it's appropriate, you know, that they should be given a way to express their opinion. You know, so it might just be a quick survey, you know, or something like that where appropriate. I think in HR, we might not need to worry about this too much, but a nice little example would be if you perhaps had a working group in your own organisation. You know, so you might get representatives from different departments and you know, different levels of seniority, all the way through you know, the hierarchy, so to speak, so that you can get a representative view from people about how we deal with personal, you know, records and things like that. Maybe. And then please do note that a controller is required to regularly review processing and that the measures that have been put into place following one of these assessments is actually being carried out. Okay, so all well and good having forked out for some state-of-the-art security equipment and you know, talked till you're blue in the face to staff about what they should and shouldn't do, but if no one's actually paying it any attention and not living and breathing it, then, you know, it was a pointless exercise. So you will need to just be keeping on top of making sure that that stays fresh in people's minds and is being conducted. And you would especially want to do a review if you become aware that risks could change. Okay, so if you hear anything in the news, for example, about new techniques that you know, cyber criminals might have developed, for example, you might want to then go and review your processes in light of it, for example. So I did promise a recap on the legal basis for data processing. Some of you might think, oh, I know this backwards now, she's talked about it so many times, but you know, it's there as one of the things that has to be included in a data protection impact assessment, particularly for legitimate interests, and it's just really such a good habit to think about your data and the lawful reason that I have to process it before you even continue look at anything else. Okay, so if we can get everyone getting this right, then, you know, I think that's a job well done. So you've got to have at least one of these, okay, to process data, full stop. If you don't think you've got one, you shouldn't have any personal data in your business. Okay, so you must have one and you need to work out what it is. You can have more than one, of course, but you really probably would only have a maximum of one or two, and it needs to be robust. Okay, so all in all, we've got 6 of them. We've got consent, contractual requirements, and that's, you know, any data that's necessary to enter into or adhere to a contract. If you have a legal obligation that you're bound to comply with, If it's necessary to protect the vital interests of a data subject, and FYI, that really is life or death situations that we're talking about there, so very few of us that will apply to. If you're carrying out the processing in the public interest, so again, I know they're really big ones, but I mentioned the examples of the DVLA and the DBS. And lastly, legitimate interest. So this has cropped up a couple of times, and it's that nice catch-all one that a lot of people are probably going to try and rely on, which is great. But you do need to make sure, as I said, that you've explained that fully as part of your impact assessment, and what legitimate interest actually is. Okay, so you can rely on this last by any of the rights and freedoms of a data subject. Okay, the fundamental rights will take precedence over your legitimate interest, which is where a lot of marketers, for example, will then have to fall back to consent. But anyway, we're not too worried about marketing. We're in the business of HR. So please do breathe a bit of a sigh of relief if you are a HR person, because if you've not already worked this out, there is pretty much all the processes that we are responsible for are things that we are legally obliged to do, for the employer. So, I'll just reel off a few examples again, just to try and help you breathe in and breathe out your sigh of relief here. But we've got a legal obligation to conduct flexible working requests in a certain way. Maternity and other family-friendly entitlements, are legal obligations. We must ensure that any dismissals, are fair and lawful. We've got to ensure equality amongst our organisation. The gender pay reporting, is a really current example. We've got to make sure we're adhering to minimum wage, that we're not breaching the working time regulations, that we are automatically enrolling anybody who's entitled to a pension if we meet the criteria. We've got to keep accident logs, so there's so many things, right to work checks, so many things there that would mean that we have to collect a wealth of special category data that we can justify right away under legal processes. So anything that you can fit under one of these headings, you should, rather than using consent, okay, especially in HR. The guidance is very much the case that if you give consent, the implication is that the consent may be withdrawn. And, if that's going to cripple you, then you really need to be finding another lawful basis to be holding data on. Therefore, if you're in HR and you've got, a load of forms or processes that are all about pop your signature here, please, for consent, you probably want to rework those, okay? And just do not ask for consent if you don't need it. It's just going to be a minefield, okay? You might get a couple of other things, under contractual requirement, like, any offers that are dependent on satisfactory references. That might be written right there into your offer letter. Benefits that you might offer and need certain personal data for, and any restrictive covenants as well, a contractual document there that might require certain information like people's addresses, things like that. So let's do a really quick recap on organisational and technological measures then, because I would like to spend a bit of time on security and we're fast running out. So I've done a worked example of recruitment for you. So organisational and technological measures, they're big words, aren't they? And sometimes they can lose all meaning if you say them over and over again. But organisational really just means literally how you're organising yourself, where things are, things like that. And technological is a bit more leaning towards cybersecurity. So I'm going to whiz through this bit. If you were thinking about recruitment processes, then you might want to consider the fact that you're going to be having, well, if people are applying directly to you, you might have a number of calls and emails coming in from unknown people. Okay, and if you've got very friendly reception staff who are willing to tell, Joe Blogs on the phone that, oh, I'm ever so sorry, the finance director's out today, they're on annual leave for 3 days, can I take a message? If that's somebody who is a professional hacker, they might have just socially engineered that person, by being very polite and pleasant, and found out that the financial director's desk is left unattended for a precise period of time, and they might then be able to hack in to their Sage account, if they found out what software they're using, for example, and hack it. And it happens. So we need to perhaps think about that and think about how we can train staff to be stringent with calls and how they answer them and provide, still be helpful, but how they answer those calls. You need to check that any third parties, so recruitment agents that you deal with, are going to be compliant as well. You will need to be implementing appropriate state-of-the-art information security systems. So I mentioned before, if you have a system that collates CVs, that's a third party as well. So you want to contact them and check how they're actually protecting that data their end, if they've got access to it, okay? Equally, hopefully they've designed that system with GDPR in mind, particularly if they're new, created in the last 2 years. And hopefully they will have arranged it so that there are certain fields and things like that that can be added, removed and tailored so that you can restrict access rights to those who really, really need them. Okay, bearing in mind that not everybody who might ultimately need that information necessarily needs it at the point of recruitment. Okay, consider monitoring your response rates. If you put out an advert and you get, a wave of response, let's say you get 100 or 200 responses, in the first week, and you're looking for one candidate, and your campaign was going to be for a month, do you really need to be collecting hundreds and hundreds more CVs, in those last 3 weeks, if it's likely that you might have got the ideal candidate sitting somewhere in that first 100? Potentially you are flying in the face of the principle of minimization if you continue to unnecessarily collect hundreds and hundreds of CVs just because you've not had time to end the campaign, or sift through the CVs that you've had so far. So you might really want to think about that as an example. You might also want to automate the removal of unsuccessful candidate applications. You might want to bear in mind any potential time frames for any claims. If someone's going to say you didn't employ me because of X, Y, Z or the other, if they were to bring a discrimination claim in an employment tribunal, they would have 3 months minus a day to do that. But do bear in mind that ACAS offer early conciliation, and potentially, all in all, that could extend the timescale by up to, well, a combined maximum of 6 months, okay, because of the various extensions that can be put in place in various scenarios. So you might decide, right, I'm going to set my systems up so that I don't even have to worry about getting rid of data that I don't need anymore, because I've date stamped these files and the computer will get rid of them all after 6 months of them being received. And you might also want to think about transferring successful applications to a personnel file, as quickly as possible, and then again restricting access. So it might have been that at the recruitment stage, you might have one person who's responsible for recruitment, and it might be actually that HR don't necessarily need to know, who all the candidates are. They might not have needed any access. But once someone's been successfully appointed, that recruiter passes Any information that is still relevant for employment, because bear in mind, we might not need everything. We might not need to know how much someone was earning in a previous job, for example. They would pass all the information that's relevant to HR, and then their access would need to be removed because they don't need it anymore once HR are responsible for running employee relations. So let's think about security. So there are many, many ways in which data can be compromised, and there are a lot of different reasons, you know, that people might try and do this to you, okay? And there's a number of examples there on screen. Now, you are only ever going to be as secure as your, you know, the person in your business with the weakest level of knowledge about security. And this subject can be quite dry. So if you were going to, you might have noticed. So if you were going to try and train staff, you know, and try and incite some engagement, they might find it, and you might find it quite interesting to have a look at this website. Now, if you've got your phones near you or anything like that, you might fancy just quickly tapping it in and having a look. But it's called Have I Been, I think it's puned. I'm not 100% struggle to pronounce it, but have I been puned? It's an odd word, but it's a basic but great little website actually, that has surprising results. So I've done some seminars recently on compliance, and you know, I'd say a third to a half of people tend to find that they've been puned, and what it means is that, you know, you have entered that email address. All right, so you log onto this website, it asks you to put an email address in. So you might put in a personal address or you might put in a work address, and it tells you whether or not that address has ever appeared in any data breaches. Okay, so for example, LinkedIn was quite a key one that got hacked a number of times, and people's email addresses that were on there were shared, you know, with others illegally. So if you've not changed your password and you've got a LinkedIn account and you've not changed it in the last few years, then get changing it, because your email address would probably come up on this website of having been puned, and it's really quite interesting. It's scary, but it's engaging and makes, you know, the topic feel very much more real. So see if staff want to have a look at that, you know, and let's not, you know, let's not get there's this false, there can be this false idea, okay, that there's some sort of crime ring of hackers, you know, who are evil and trying to get your data. But the reality is, you know, there's very few people who are evil. People have got motivations for what they do, you know, and people want your data. People in desperate situations want to make money, you know, they want to sell it. There could be sinister things like blackmail or ransom, like with the NHS last year, and all their data got held to ransom, or loads of it anyway, or fraudulent activities. But equally, anybody with, you know, strong political views who wants to attack an organisation to make a stand, you know, or even people who might want to just, you know, compete, you know, with their friends on who's the best digital whiz, you know, or just bored, because you can't just go online and download software for free that enables you to hack businesses. Okay, it takes one disgruntled individual who's, you know, been dismissed or not had a grievance upheld, you know, to decide to get on the internet, talk to, you know, someone who's clued up, you know, or even not that clued up, and download these sorts of things and wreak havoc, you know. And it's quite often not personal, it's quite often just people, you know, almost just doing a scattergun approach. So I'm conscious of the time. We'll just keep going for a couple of minutes. If you do have to get off, then, you know, we have got this online again. But when we think about data security, you know, a lot of it, a lot of the phrasing that's used, particularly if you speak to IT people, is about protecting the king, okay, and all the bits and pieces that you've got around it to protect that king. So it's those bits and pieces are both the physical and cyber security measures that you would put in place to protect that data. Right, so this sits quite neatly with the technological measures that are required under GDPR. Now, in terms of physical security, and I suppose this one would be organisational security. You know, you might have quite a lot of these things in place already that you can document as measures. So secure entrances with, you know, key code access. Please make sure that they're changed regularly whenever you have a lever. You might also have internal secure areas like locked cupboards, and again, just make sure that key doesn't sit too close by and it is stored safely away when no one's around. You might also invest in some privacy screens, which can be bought from a stationery shop, you know, for a laptop. And if you put that in front of your screen, it just prevents anyone sitting next to you from seeing what you're working on. And just things like frosted windows, you know, and how your office is laid out to prevent footfall in any areas that might particularly deal with sensitive information, like HR and finance, for example. And then cybersecurity. So I've got a diagram for you here. So right in the middle of your organisation would sit all the personal data that you have and are responsible for, which needs to be prevented from leaking out. So surrounding that, from a cyber perspective, this is all, okay, you would have, or you might have, a firewall. You might then have DNS cloud umbrella. And then around that, you might have antivirus software. And around that, you might have anti-malware scanners. And these are all things that can be triggered and flagged to prevent certain types of hacking, you know, or attempts, phishing scams, things like that, from accessing that data sat in the middle. Now, you might then want to invest in penetration testing, which is essentially where an ethical hacker would try and break through each of these rings to get to the data, and they would do you a report on how far they managed to get. Okay, now that is an excellent service, but it can be expensive. The concept still, though, I would hope, is something that you can take away in terms of thinking about where the leaks are, where are the gaps, how can somebody who's tech savvy get into our systems, okay? And please, if you don't think you know an awful lot about data, then please get yourself on some professional training and please roll that out to your staff as well, okay? Because there are all sorts of things that can happen that I've become aware of that I didn't know, you know, just 5 or 6 months ago, you know, and it just takes that little bit of investment to be a lot more secure and stronger, you know. People could take a hard drive out of your laptop, okay? You might think, well, I've got a password protecting that. Well, that's not going to do a lot if somebody were to steal your laptop, you know, because they can then remove the hard drive, plug it into a piece of software they've got at home and bypass your password totally, okay? And then they've got access to all your records that are kept on your laptop, you know. So we have got to get savvy. And as part of raising awareness, you know, preventing staff from, you know, being your weak links, there are a couple of links here that you might want to have a look at, which provide some free material, you know, posters that you could just go and put up, you know, by the printer or by doors that should be kept shut or locked, you know, things like that, that can be really, really useful. So feel free to have a look at those. And lastly, you know, remember, we've mentioned them briefly, but if you do have any third parties, particularly people that use any cloud-based storage systems, you know, think about where in the world they are and ask them to tell you how they're preparing for GDPR and what security arrangements they have got in place, okay? And it might sound dramatic, but you may really want to reconsider arrangements with anybody who's not convincing you. Okay, just see whether or not that they can repeat things, you know, that you've heard and seen and done, and if not, they probably haven't got a clue. To be honest, that seems to be the case anyway. So we are at the end now of this webinar this afternoon. I hope you have found it informative. We do have seminars. I have my next seminar coming up on the 28th of March. If you would like to come along, it would be great. We've got the places filling up, but there are some still available. And we really work through compliance with you and go through particularly each of those steps of a DPIA to help get you compliant. And there's loads of great things in there and tools that you can take away with you. So yeah, get in touch, let me know if you're interested in coming along, it would be great. And yeah, so if you have got any questions, please do just pop them over to me now in the dialogue box. You've got a few seconds left to do that, but otherwise you can contact me directly and I'll try and get back to you in the near future with any odd questions that you had about this webinar. But we will wrap up now, as I have gone on, as I tend to do. So do feel free to give me any feedback so I can keep these current and relevant for you. And thank you very much for attending today. It's been a pleasure to have you along, a pleasure to see a number of people who've attended previously, and I hope that you'll join me again next time. And all the best. Enjoy the rest of your day. Bye.